Session, you may be seated.
Good afternoon, Your Honor. Good afternoon, all. This is 2383CR198, the case of Commonwealth versus Lindsay Clancy. This case is called for motion hearing. Counsel for the record, begin with the Commonwealth, please.
Good afternoon, Your Honor. Jennifer Sprague for the Commonwealth.
Attorney Sprague, good afternoon.
And Shannon Buckingham, also for the Commonwealth.
Attorney Buckingham, good afternoon.
Good afternoon, Your Honor. Kevin Reddington on behalf of Lindsay Clancy, who I believe is with us on Zoom. Yep, she is.
Attorney Reddington, Ms. Clancy, good afternoon.
Good afternoon.
All right, so this was put over today in regards to a couple of motions that had been filed by the defendant. Commonwealth filed their opposition, which I had an opportunity to go over. So why don't we deal with, there was a motion regarding juror information. My thought on that was to maybe defer on that, only because we're going to have to figure out, it's so early in the situation now, we're going to have to find out how many jurors are coming in, who's coming in. I have no problems allowing that motion, but just to have a better idea of the specifics. That was kind of just my thought, but well, I guess Mr. Reddington, your motion, I don't know what your thoughts are in regards to that.
I know when to defer, and I'll defer to you in your judgment in that regard, because obviously you're not opposed to our getting access to the juror information well in advance of trial for us to do our investigation, so that's fine.
All right. Como?
I have no objection to deferring either. I just would point out that the Commonwealth filed its own motion because we're looking for slightly different information, and we're objecting to a portion of the information defense is requesting. So I do think at some point we just need to hash that out.
All right, we can do that right now.
Okay. The only thing we're objecting to is the contact information of the jurors. I don't think we're entitled to that, and I don't think we should have that prior to trial. And that, I believe that was in defense counsel's motion. In our motion, we're just looking for the dates of birth, the addresses, and the names.
All right, Mr. Reddington?
I agree, Your Honor, that my understanding of the status of the law as it relates to contact with jurors is that once we actually start a trial, we're not supposed to, for obvious reasons, which is fine. And then you have the Fiddler case, it talks about post-verdict. I tend to agree as far as the request for contact info. I would not be thinking in any fashion of having a private investigator go out and talk to potential jurors or anything. I just need to know who they are and their addresses, that's all.
All right, so my inclination would be not to allow the contact information, but the rest of the information. So my thought would be to put this off till a little bit farther down the road so we know kind of when we can get that information, and then I can kind of tailor the order along with that after we talk to the jury commissioner and figure out the jurors that are coming in. But like I said, I'm inclined to give that other information to both parties in advance of the trial impanelment. So, all right. The other motion that we had was regarding the bifurcated trial. So why don't, Mr. Reddington, I'll hear you on that, and then I'll hear from the Commonwealth.
Thank you. Your Honor, first of all, as you know from looking at my motion and the memoranda, also from looking at the government's opposition, there is a bit of a dearth of law on this issue, quite frankly. I think that's not just statewide, it's pretty much nationwide. But one of the things that's really compelling to me in reviewing the language from the various opinions is that there's no doubt that this is commended to the sound exercise of discretion by the trial judge. So you've got two issues in play here. Number one, do you, as the trial judge, feel that, in fact, it's a legitimate concern that we've raised and it's a legitimate procedural proposition that we present to the court as far as the logistical considerations involved in trying the case in a bifurcated sense, and then also the constitutional implications, if any there are. And I suggest to the court that, first of all, the government has quoted the many times quoted Siegfried case, 88 case, dealing with a guy that burnt down a dwelling house, and they're talking about basically, the introduction into evidence of prior testimony of a witness in a probable cause hearing, and the witness was then unavailable. But in dicta, they do talk about the fact that it does not appear as though there is a constitutional, let's say, obligation, if you will, on the part of the court to provide a defendant with the bifurcated trial. But they don't really get into a consideration of that, and they don't really get into a discussion of it. They talk about cases that had been cited in the past, Commonwealth versus Bumpus, MacArthur versus California, and these go back, they go way back. Commonwealth versus Stewart at 359 Mass is one that where the court notes that one issue that's of a concern is that you have the issue of criminal conduct is their language, the way they use it, criminal conduct and criminal responsibility. So we have two separate concepts that would have to be presented during the course of a trial to a jury. One, whether or not the defendant is in fact determined by a fact finder to be guilty of the offense as indicted or any lesser degree thereof, and whether or not that person has the mental, and again using the SJC language, mental responsibility. Now I think that the cases are fairly old, that's 78, thereabouts, so that's why they're using language such as mental responsibility. As we all know now, we're talking in terms of the defendant having the ability to know, and the government's burden of proof, beyond a reasonable doubt, not only as to whether the person has committed the offense, but whether or not the defendant at the time of the commission of the offense was suffering from, or was not, I should say, on the government's obligation to prove to a jury, defendant was not suffering from a mental disease or defect, such as preventing the defendant from either, it's in the disjunctive, either understanding or appreciating the criminality of his or her conduct, or to be able to comply and conform to the requirements of the law. That's black letter law definition of the lack of criminal responsibility, which is a separate issue and has been recognized as such by the SJC, as I say, in Commonwealth versus Stewart. I believe in some other cases in dicta, they recognize the fact, which we all, I think, recognize, that there are two issues: defendant's mental state and whether or not the defendant committed the offense. Now, this is where it gets into what I think is very interesting as it relates to the Massachusetts Constitution as opposed to the federal Constitution. Now, Massachusetts Constitution, as Your Honor is well aware, predates the United States Constitution. And in fact, the framers of the United States Constitution drew upon language, for example, on the issue of the Fifth Amendment. They drew upon language that our framers of the state constitution said that no person shall be compelled to give evidence against themselves. U.S. Constitution talks about no person shall be compelled to give testimony against themselves. So there's a difference there, as Your Honor is well aware. Excuse me. So when you consider the Massachusetts Constitution and the fact that that has traditionally provided greater protection to a citizen than the United States Constitution, I'm suggesting that under the Massachusetts Constitution, coupled with the dichotomy between defendant's mental state and the commission of the crime, coupled with the government's obligation to prove beyond a reasonable doubt, and then coupled again with the defendant's constitutional right not to make any effort to present any evidence against himself or herself, that in fact the court should be able, in the sound exercise of discretion, to determine that if you have a trial and the defendant is compelled to go to trial not only on the obligations that the government has as to proving guilt of the offense, whether it's a bank robbery whether or not it's a alleged rape, whether or not it's a homicide. The government has to prove that the offense occurred. However, you've also got that next layer, which would be whether or not the defendant has, as the SJC says, mental responsibility. So if you consider it in that fashion, we do not have to present and should not have to present evidence in the, let's say, guilt phase of the case. So if you have the guilt phase of the case, and then you have the criminal responsibility phase of the case, if Your Honor denies this motion, we try the case the way they're all tried. Government presents their case, presents their evidence, determining whether or not jury's going to find this defendant guilty. Then I have an obligation to present evidence that would be consistent with the lack of criminal responsibility, and evidence of that lack of criminal responsibility will obviously implicate criminal liability. So that's the problem that we have in this type of structure that we deal with. And that's why I think that it's very, very appropriate to have the bifurcated trial as requested in the motion. So, looking at the other cases that I've looked at, I think clearly where you have the U.S. Constitution, they have the, let's say, the minimal protection. The Massachusetts Constitution provides a greater protection. And a defendant should not be placed in a position of presenting evidence in the course of a trial because, for example, in the grand jury, you have wonderful first responders. And what these people went through is just horrific. But they had one witness after another, after another, after another, after another, firefighter, 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 EMT, police, all describing the same thing that they saw when they went into that house. And that's going to be a replay on the trial itself. So the government should be in a position of presenting their evidence on criminal activity without trampling on the defendant's right not to be presenting evidence, quote unquote, against herself in that phase of the trial. And if we were to have the bifurcation, that would solve that problem.
Let me ask you, because I did have an opportunity. I read through kind of the same cases everybody's read through, you know, Siegfried, Blanchett, all these other cases.
Right.
And I would agree, the phrase dearth of law does seem to apply. How would you suggest procedurally doing this?
That they proceed with their evidence as it relates to the circumstances involving the death of the victims in this case and the circumstances surrounding what the police observed, circumstances surrounding any, as the government argues on murder cases, whether or not a person had knowledge, whether or not a person took pleasure in, for example, the suffering of the victim is one of the Hunter and Cunningham factors that we've talked about over the years with first-degree murders. That all goes on the issue of criminal liability. Doesn't really touch upon criminal responsibility. So in the event that, in the first phase of the trial, on the responsibility coming after, I suggest to the court, a jury could return a verdict. They could say, okay, we've determined that the government has sustained its burden of proof beyond a reasonable doubt. We find the defendant guilty based on the facts that have been presented, and then it moves into the issue, which really is the main issue in this case, of lack of criminal responsibility.
So I guess what I'm struggling with is the jury would come back with a verdict
Based on the facts.
based on the fact guilty or not guilty. We'll assume it's guilty.
Correct.
And then would you ask them to undo that?
No. Then you get into the second phase of the case, which deals with criminal responsibility. which is got to be a major consideration, and it should be a major consideration, which it would be if it's bifurcated, and if you have the initial phase is resolved by way of the factual evidence that the government has, telephone call made, 911 call made, witnesses appear, witnesses observe, witnesses saw, pathologist, results of the pathology examination, all of that goes in the first phase of the case. Then, after that is resolved, we get into the issue of lack or presence of criminal responsibility. And then we get into the issue of whether or not defendant was suffering from a disease or a defect, as a result of which she was unable to appreciate or conform.
All right. So, all right, Commonwealth?
Thank you, Your Honor. The Commonwealth presented three basic reasons why we're opposed to this motion. The first, obviously, is that the defendant does not have a constitutional right to a bifurcated trial. And that's not just from the Siegfried case in 1988. It was citing Bumpus from 1972, but it was also upheld in cases in the 80s as well as the 90s, as most recently in a case I found in 1996. So this is something that's been law in Massachusetts, that you're not entitled constitutionally to a bifurcated trial. Defense counsel brought up the Fifth Amendment issue and how that's different in the Massachusetts Constitution, but the SJC has already made it clear that when defense counsel and defendant choose to have the defendant interviewed by a psychiatrist and raise these issues and interviewed about the event, that they're waiving their Fifth Amendment privilege. So that doesn't come into play any longer once that's done. And that's been done here, and the intent here, as in Blaisdell, is to present that to a jury. The second issue is that the two trials would be nearly identical. Defense counsel has stated that certain witnesses might not be called, such as EMTs who come in and see the bodies of these three little kids on the floor in the basement. But Commonwealth argues that would be admissible evidence in the criminal responsibility portion, because it does go to mens rea. It goes to what she did, how she did it, why she did it, what her thought process was during that, how she planned to do that, and how much time she needed to do that. So these would basically be two identical trials, just like Commonwealth versus Scott from 1990 states that the evidence of a lack of criminal responsibility was related to the mens rea component of the crime itself as well. So you'd be having duplicate trials for no reason if we were to proceed in a bifurcated manner. All of the case law that I have found has been in instances where the courts have repeatedly denied a bifurcated trial, and the appeals court and the SJC have repeatedly upheld those decisions. And in his motion, defense counsel did not cite any reason whatsoever to make this case different than any other cases that have been heard in this county or elsewhere in the state, and cited no case law to support this request. So I'd ask that you deny the motion for those reasons.
All right. Anything further?
Very well.
All right. I'm going to take this under advisement, which is I want to go back. I read through all those cases. I want to go back and read through, considering the arguments of counsel. So I'm going to take that matter under advisement, but I'll get that decision out as soon as I can, because depending on what the decision is, might weigh in on the trial schedule and things like that. So I'll get that out as soon as I can. Is there anything else?
Your Honor, there had been defense counsel's motion to record the forensic interview. We've come to a stipulation regarding that. The parties have agreed that the interviews of the defendant would be recorded in the manner proposed in defense counsel's motion. However, the testing portions will not be recorded. Defense counsel has signed for his client today. We plan on providing defense counsel with another copy so that the client can sign it herself, but we could submit this as a placeholder to the court, or would you prefer we wait?
Well, my thought is it's probably good to have it in the file, then I can look at it and review it in regards to that. But and so, Mr. Reddington, if you get that when Ms. Clancy has an opportunity to sign it, that's fine. But I have that. I accept your presentation that you've gone over that with her.
Yes. Okay. Thank you.
Now, so the date, if I remember, sometime in April, wasn't it? The evaluation?
Yes, Your Honor. April 10th, 11th, and 12th.
Right. And I know that we have dates at this point, June 18th, July 13th, and then trial date, July 20th, correct?
Yes.
Does it make sense to maybe pick a date, maybe towards the end of April, after the evaluation, just in case any issues kind of come up that we need to deal with, in regards to that? I just, you know, things happen sometimes, so it'd just kind of be a good idea to kind of touch base with everybody.
Yes, Your Honor.
Mr. Rankin?
Yes.
Or where you're gonna be sitting, Judge.
Do it here. I'm gonna be in Denham, but I can come here. It's probably easier for me to come over here.
Maybe, Friday the 24th of April?
I'm available.
I'm supposed to be in Dedham at 2:00 in the afternoon, and I also, somebody put in my calendar, New York Yankees and Houston Astros. I don't know what that's all about. I think it might be my secretary, but, I could not be here unless I continue the matter in Dedham, which I can certainly reach out and try to do. It's a motion to suppress.
We have flexibility, Mr. Rankin. How about the 1st of, May, which is the week following? That's a Friday as well.
I'm available.
It's a Friday, right?
Yes.
Yes.
I gotta be in, again, I gotta be in Dedham. On another matter, motion to suppress.
Thursday the 30th or Thursday the 23rd?
And this would be at 2?
2.
I could do the 23rd. I'm not available the 30th.
I can do the 30th, not the 23rd. Wait a minute, let me check one thing on the 23rd.
Maybe if we went back
So I could,
Friday before that,
wait a minute, hold on.
17th?
The 23rd, I have to be in Barnstable in the morning, but I could be here in the afternoon.
All right, does that work?
Yes.
All right. And that's for status regarding the evaluation and any other discovery issues that might
Yes,
come up as a result of that.
good.
All right. Anything else we need to address?
No, Your Honor.
No, thank you.
All right. So thank you very much, Ms. Clancy. Thank you.